Well, friends, welcome back to this panel on religion and democratic society. My name is Eric Gregory. I teach religion, ethics, and politics at Princeton University. And our feast continues with three speakers well known for their work in this area. And following the precedents, I'm going to be embarrassingly brief because their bios are very available to you in the program. Our first speaker will be Andrew March, who is an associate professor at the University of Massachusetts and a visiting scholar at Harvard's Middle East Initiative. And his research and teaching interests are in the areas of Islamic law and political thought, religion, and political theory. His book, Islam and Liberal Citizenship, is an exploration of the Islamic juridical discourse on the rights, loyalties, and obligations of Muslim minorities in liberal polities. And his second book is forthcoming, The Caliphate of Man, The Invention of Popular Sovereignty in Modern Islamic Thought. And he's going to be talking to us about reading Rawls in Tunis. Paul Weithman, the second speaker, is the Glynn Family Honors Professor in the Department of Philosophy at Notre Dame. He earned his PhD in philosophy at Harvard, where he wrote his dissertation under the direction of John Rawls and Judith Shklar. And he works primarily in political philosophy and history, and its history. And his most recent book is Rawls, Political Liberalism and Reasonable Faith. And he'll be talking about liberal society and deferential treatment. Jeremy Waldron teaches legal and political philosophy at NYU School of Law. Until recently, he was the Chichely Professor of Social and Political Theory at Oxford. And he has written extensively on jurisprudence and political theory, including numerous books and articles on rights, constitutionalism, the rule of law, democracy, property, torture, hate speech, security, homelessness, and the philosophy of international law. And in his book, Political Theory, he argues in favor of reorienting the theory of politics towards institutions and institutional principles of democracy and the mechanisms through which ideals are achieved. And he'll be talking about religious interventions in political debates. So, Andrew, can you come?
I'll be equally parsimonious in my expressions of thanks. Thank you, Eric, for that introduction, Michael for the invitation, Ludek for all the support, and especially the Safra staff for everything that you guys are doing. As Eric noted, oh yeah, that's the first time anybody's ever told me that. Yes, exactly. So I was doing that intentionally, actually. So my first book, as Eric noted, was directly on the Rawlsian theme of the possibility of an overlapping consensus between political liberalism and Islam as a comprehensive doctrine. I won't dwell on that here, except to note that after that project, my interest in Islamic political thought veered in a different direction, toward modern reconstructions of Islamic law, Islamic philosophical anthropology, and the dialectic of divine and popular sovereignty in modern Islamic thought, which is the subject of the book that I'm presently finishing. I did not intend for this project to have any deep resonances with Rawlsian themes. I was interested in a particular problem internal to Islamic thought, and I think it was also probably eager to not brand myself too narrowly as the Rawls and Islam guy. But moreover, where Rawls's theory moved outside of the North Atlantic, it never seemed as strong or as insightful. Why speculate about an imaginary Kazakhstan when the questions of public justification, moral and metaphysical pluralism, and the foundations of a social contract have been the subject of Islamic political and legal thought since at least the mid-19th century? And yet today I have a story about the surprising resonance and relevance of Rawlsian themes and perhaps predictions in a very specific non-European and non-American context. Specifically, I want to talk about the Tunisian democratic transition and the place of Islamic political thought in challenging the terms of that transition, then helping to author it, then providing comprehensive Islamic religious justifications for a democratic constitution based on political and moral pluralism, the constitutional guarantee of human rights, and popular sovereignty on a secular national basis. What is interesting is not that this happened. We don't need philosophy to explain the pragmatism of real-world actors. And it is not a clean-cut story of, lo and behold, any given comprehensive doctrine can become reasonable and endorse a system of social cooperation on liberal terms. Rather, what is interesting is that despite lots of skepticism and even abusive criticism directed towards the ideas that the compatibility of a public conception of justice with religious comprehensive doctrines matters, and that this framing has anything to tell us about the democratic public sphere outside of narrow debates within certain Western countries, certain Islamic political thinkers have found themselves, almost certainly unwittingly, structuring their thinking about the foundations of democracy and conditions of quite radical political and moral pluralism in surprisingly Rawlsian terms. These themes and concepts include the following: the relationship between an ideal theory and non-ideal theory and how we know the difference, the distinction between reasonable and unreasonable disagreement about fundamental moral matters, the assumptions about the kind of moral agreement that is required for justice and stability in a well-ordered society, how norms or values that may have deep foundational justifications in a comprehensive doctrine have to be justified in public in conditions of disagreement, what kinds of moral agreement are possible given the fact of actually existing pluralism and why, whether agreements to abide by a constitutional order are something like a modus vivendi, a constitutional consensus, or an overlapping consensus. And finally, whether adherents of comprehensive doctrines ought to revise their comprehensive doctrines to make them more compatible with a publicly accepted conception of justice. But first, to back up, it is important to note that for all of the complexity of the political behavior of Islamist political groups in the last 50 years or so, the Islamist political movement produced a rather sophisticated ideal theory of a regime type, which I call Islamic democracy. In my view, the most elaborate and sophisticated theory of this alternative ideal regime type has been formulated by a philosopher and politician who is both a transnational symbol of Islamic democracy before the 2011 Arab Spring, and perhaps the figure most responsible for the Islamist co-authorship of the post-revolutionary 2014 constitution, Rashid al-Ghannouchi. And I think this does not work, so that's him in his politician mode. So we have here a case of a single figure who is both an intellectual and a politician, both a philosopher of a democratic but non-liberal ideal theory, and a statesman who helped author and stabilize in real but non-ideal conditions a liberal pluralist constitution. I'm also rather fortunate here for present purposes in the fact that he is still living, and I've been able to spend many, many hours with him discussing these very topics, and I think to a limited extent introducing him to certain Rawlsian concepts and questions. He was trained in philosophy in Paris in the 1960s, but for all of his time that he spent in exile in London, did not appear to acquire deep familiarity with Rawlsian and post-Rawlsian political philosophy. So first, very, very briefly, what are the features of this democratic but non-liberal ideal theory that I'm referring to as an Islamic democracy? So the first three are the democratic features, and when they claim to be offering a genuine theory of democracy, it's largely because of this. Nobody has the right to rule without popular consent, but the constitution that governs a society is subject to wide-ranging constituent popular democratic authority, and it's not just merely given by Islamic law. The people also has a right to participate in lawmaking, so some of the sort of distinctions between sovereignty and government are actually broken down in a more democratizing direction in this theory. But these last four point to the fact that it is a very, very much non-liberal Islamic theory of democracy. It's rigorously perfectionist, the purpose of politics, you can see the quote there, to create the conditions for as many people as possible to live in innate accord with the divine law. Divine sovereignty doesn't go away. They take the divine law seriously as something that constrains politics. Most importantly, it is a theory that emphasizes and assumes moral unity rather than reasonable pluralism and competition. There are extensive discussions of Montesquieu and Madison and how those theories of managing pluralism are not relevant to a Muslim society. And then finally, there's a distinct philosophical or theological conception of the person and society, both individually and collectively, as the caliph or vicegerent of God, and that's the title of my book, as Eric mentioned. So the only point here is to mention that while I do believe that they have an authentic theory of democracy, it is one that would not have predicted or called for or rationalized the kind of constitution that was created after the Arab Spring. So I would not call this a decent hierarchical regime, as Rawls calls Kazakhstan. It's more of a radically egalitarian, almost Protestant, democratic perfectionist political order where the conception of the person is built around this theological anthropology of man's universal vicegerency of God. It's tolerant to a certain extent and protects certain civil and political liberties, but it's not liberal and certainly not politically liberal in Rawls' sense. Now fast forward to the period between 2011 and 2014 when Tunisians were drafting a constitution and a democratically elected National Constituent Assembly. Ghanouchi's party, the Ennahda, or Renaissance Party, was the single largest party in democratic Tunisia and remained so. They had 41% of the seats of the Constituent Assembly, so they were the largest, but obviously not able to dictate the terms of the new order. What resulted after almost 3 years was a secular democratic constitution. Islam was declared the religion of the state, and the president must be Muslim. But there was no mention of the Sharia in the constitution. International human rights were declared to be universal. Gender equality was enshrined. A provision criminalizing blasphemy was rejected, and political pluralism at the party level was guaranteed. Now again, his party was crucial in negotiating, debating, drafting, and ultimately defending this constitution. In the wake of this, his party formally declared itself in 2016 to no longer belong to political Islam or Islamism, but to something called Muslim democracy, styled after European Christian democratic parties. What followed also were certain doctrinal statements and articles, essays, speeches, and sermons of how they now understand the relationship between religious truth and political order. So from the outset, we see something of Rawls's prediction that, quote, once political groups enter the public forum of political discussion and appeal to other groups that do not share their comprehensive doctrine, it is rational for them to move out of the narrower circle of their own views to develop political conceptions in terms of which they can explain and justify their preferred policies to a wider public so as to put together a majority. And as they do this, they are led to formulate political conceptions of justice, et cetera, et cetera. Now, what are the contours of this new ideology, this Muslim democracy that is supposed to be different from Islamism? The distinctive features are the following, these following 5. So first, politics is primarily conceived as a form of contract between parties around specifically worldly rather than metaphysical or otherworldly goods. Second, that there's a recognition of the fact of pluralism, not necessarily the fact of reasonable pluralism, that the existing range of disagreement in society is a constraint on politics. 3, that agreement and consensus is the first virtue of politics at the constitution-making level. 4th, that the meaning of the Islamic Sharia now means something like the rule of law in a generic sense or limiting arbitrary executive government. In 5, there is a master kind of religious metaphor for this sort of politics. He moves away from the doctrine of the universal caliphate and says the founding moment of Islamic politics was when the Prophet of Islam, Muhammad, entered the city of Medina, which was occupied by Jewish tribes and pagan tribes, and established a kind of covenant. So their argument is that Islam was born not in power, but in a covenant in the conditions of radical pluralism. All right. So I don't have time to go over these in massive detail, but I want to introduce a few choice quotes. So first he writes that this first written constitution in Islam, Medina, codified an essentially pluralist political formation, and that, quote, we Muslims are lucky that our first state was a pluralist state. In a later essay, he reiterates that the founding of Medina provides Muslims with the authoritative example of founding a pluralistic political order with citizenship, not religion, as the fundamental principle of rights and duties. The fundamental mechanism of political order is contract rather than moral formation. The Covenant of Medina presents to Muslims the model of the Prophet establishing a state on the basis of contract in a radically religiously plural society, one that doesn't only include Jews and Christians, but also pagans and materialists, a state that establishes a civilizational model, this is still quoting him, open to all mankind, capable of assimilating and incorporating all creeds, cultures, and races, within a contractual and civilizational framework without expulsion, wars of cleansing, or plans for forced assimilation. He uses this understanding of Medina not only to argue for a limited conception of politics and to justify political cooperation with non-Islamic parties, but to also argue for a broad consensus model of constitutional politics, the creation of the basic structure of society. What is interesting is that Ghannouchi does not merely defend these as necessary compromises given the balance of power, or as, quote, the best we could get, but as a distinctly political choice to prioritize stability over partisan goals. Rather, he advances a view of consensus as the highest principle of legitimacy, particularly in constituent moments. You see the quote here: the Constitution must not be seen as the constitution of a particular party, but rather of the entire country, in which the entire range of political, intellectual, social trends are found. Therefore, when the question of Sharia was proposed, we found that it is a matter of disagreement. But constitutions are not adopted on the basis of what there is disagreement around, but rather on what there is consensus around. Of course, he always knew that many contemporary Muslims did not wish to enshrine the Sharia as the governing law of their society. And yet his entire intellectual project was traditionally an interpretation of what it means for a Muslim community to govern itself by the Sharia. And in some of that previous writing, the rejection of the Sharia itself was not treated at all as a reasonable disagreement, but as a cause of enmity. Yet in the Constitution drafting period, the view is that it would be unreasonable or inappropriate to base so foundational a concept of legitimacy and legislative sovereignty on a controversial principle. But why? What makes disagreement about the Sharia itself reasonable or worth respecting, rather than mere disagreement on specific points of the Sharia? He does not elaborate on this question. What he does say is that the Constitution must be adopted on the basis of human values because we are a part of this humanity that crystallized and clarified a number of principles, such as the principles of democracy and human rights. You can see the second quote there. So you see this kind of quasi-Rawlsian move to move away from arguing on the basis of your comprehensive doctrine to something that is freestanding and presumably eligible for agreement or argument with others. But this Rawlsian approach raises one obvious question. What kind of moral accomplishment is the 2014 Constitution, and what is the nature of its overlap with Islamic doctrines? A few things here, very briefly, need to be observed. I do not believe that his justifications for the new Constitution are merely a modus vivendi, that they're tactical or insincere. But they're very thin and doctrinally ad hoc in comparison with the previous ideal theory. So you have this kind of question, this theoretical question: if this is your comprehensive doctrine, and it's very, very rigorously argued for, very comprehensive, very sophisticated, very dense, and this is your non-ideal, public reason version of your own comprehensive doctrine, does there have to be a symmetry in the depth, the sophistication of argument, and presumably the sort of the ability of it to persuade members of your own comprehensive doctrine, regardless of their present political commitment? So you have a kind of asymmetry, an intellectual asymmetry between both iterations. Second, he does not have, in my view, a really deep, comprehensive theory of the difference between reasonable and unreasonable pluralism. In conversation with him, I have used the example of the American Constitution's acceptance of slavery as the paradigmatic example of an evil compromise. His view is that the 2014 Constitution is itself not sacred and thus capable of being changed, but he will not give a firm view on what would be an unreasonable or evil form of compromise with disagreement. Third, he's given reasons for the acceptability of the Constitution from plausible religious commitments, but his preference is to do so without reference to his prior doctrine. He suggests kind of a continuity in his views, or even when he acknowledges that the Constitution required compromises and concessions, he does not expressly say whether accepting those compromises means revising earlier views on the fundamental basis for political life. So we're tempted to sort of see this as a kind of paradigmatic example of a constitutional consensus, as Rawls puts it. I don't need to read this all out. We're all very familiar with this. So there's on my reading, there are two particular questions of interest. If you would want to test the depth and the stability of this and its ability to ground something thicker than a mere constitutional consensus. One is the idea of Sharia permanently limited to the role that he gives of limiting government, or is this something future Tunisians might revise in different political circumstances in a generation or two when a supermajority shares a kind of return to religiosity? And second, are non-Islamic comprehensive doctrines themselves metaphysically and intellectually reasonable or merely tolerable and acceptable? While Muslims have obligations to respect the freedom of conscience of others, should differences around the fundamental acceptance or rejection of Islam itself be seen as something internal to reason or as a failure of it? Virtually every other principled question follows from the conception of justice and the permanence of pluralism. There are reasons to think that the present constitutional compromises may have principles but still be compromises. First, there's no deep account offered of why disagreement about the Sharia itself is reasonable or worth respecting. Rather, there's the observation that presently the question of Sharia is too divisive, like slavery in the 1787 American Constitution, and more intriguingly, that the objections of Tunisians to Sharia rest on misunderstandings of what the Sharia is and the manipulation of radical secularists. Second, there's reason to believe that Ghannouchi still regards secular comprehensive doctrines as insufficient grounds for a principled moral life. In a 2013 essay entitled Human Rights in Islam, he writes that, quote, the general direction of human rights declarations and international covenants are in accord with the precepts of Islam, but the experience of humanity shows that humans do not live without adopting God in some fashion. Quote, in the human soul, there is a hunger that is not satiated except by accepting God. I think Rawls, circa 1942, would have agreed with that. In my conversations with him, and I have spent more time trying to ask this in different ways and in different formulations than anything else, he's been reluctant to see materialist or non-theist metaphysics as potentially rational. At one point, I tried to present Kant's antinomies of reason, and he simply declared Kant is wrong, that there is an antinomy of reason on what is the origin of the universe and what is the cause of the world. So at some level, his radical commitment to political pluralism, which does accommodate even communist and other atheist parties, is ad hoc and unfoundational rather than grounded in a deep moral epistemology of reasonable pluralism of metaphysical doctrines. So to conclude, it's most probable that the present relationship of Islamic doctrine, as understood by this one important figure, to the 2014 Constitution is no more than a constitutional consensus that Islamists can nonetheless be content with for principled reasons. Some of them Islamic, some of them freestanding, and some of them derived from political experience. Now, one possibility, as theorized by Rawls, is that the practice of politics will make the liberal principles embedded in this Constitution attractive and irreplaceable given the permanence of moral pluralism around questions of religion and ways of life. Over a long enough period of time, the political compromises involved in accepting the Constitution will be given some deeper theological justification, some way of explaining rationally disbelief. Another possibility is that with demographic change and perhaps political crisis, future Islamists may feel entitled to embrace the consequences of being the social majority. So I'm not sure what philosophical questions this has raised or provoked in this audience, but I look forward to finding out. Thank you.
John Rawls devotes section 79 of A Theory of Justice to what he calls a social union of social unions. In that section, he conjectures that a society well ordered by justice's fairness would be home to a diversity of collective pursuits which would have shared final ends and which participants would judge to be good in themselves. He then argues that because of a psychological phenomenon he refers to as the companion effect of the Aristotelian principle, members of the well-ordered society would experience the diversity of their society as a very great good. The conclusion that they would functions as a premise in a further argument that Rawls offers at the end of section 79 and that he recapitulates in section 86. In the latter section, it's one of several arguments Rawls offers for the claim that members of that society would have weighty reason to judge that their sense of justice belongs to their good, and that those reasons would be decisive. The upshot, Rawls says, is that, quote, the hazards of the generalized prisoner's dilemma are removed by the match between the right and the good, unquote, and a well-ordered society is as stable as one can hope for. I find the arguments of Section 86 fascinating for a number of reasons. One is that they draw together in an ingenious and satisfying way many of the threads unspooled in the preceding 200 pages of Theory of Justice. Another is that they display, to an extent that I think has still not been completely explored, the deep Kantianism of Rawls's thought at that stage. Still another is that Section 86 is ground zero of the dissatisfaction that led Rawls to turn to political liberalism. His dissatisfaction with some of the arguments of that section occasioned his search for a different treatment of stability. His subsequent delineation of the domain of the political and his reconstruction of his theory within that domain in political liberalism, okay, complete with its Kantian profile, is a truly impressive intellectual achievement. Well, Rawls signaled one source of his dissatisfaction in a note to reply to Habermas, which has, I think, escaped attention in the literature. There, Rawls seemed to imply that he no longer accepts the argument in Section 86 that was drawn from Section 79, for he clearly implies that one of the reasons that he rejected theory's argument or treatment of stability and made the transition to political liberalism is that he came to think, quote, the conception of a social union of social unions is no longer viable as a political ideal once we recognize the fact of reasonable pluralism, unquote. Well, although Rawls had second thoughts about the argument of Section 79, it remains of considerable interest. For as in so many of the arguments out of which justice as fairness is constructed, so in this one, Rawls formulates a question that liberal theorists have to confront, stakes out a position on it, and defends his position using a novel and imaginative strategy. That question, at first approximation, is how citizens of liberal societies are to regard their own participation in the way their societies create space for pluralism. This is a question that can be raised not just about the well-ordered society of justice as fairness, but also about liberal societies as we know them. When it is, as it will be in this essay, the attempt to answer it is part of a non-ideal liberal theory. If we are to raise it in non-ideal theory, we have to know what makes a non-ideal society liberal. In the longer version of this paper, I lay down three necessary conditions. One, that they protect basic rights and liberties, including freedom of the press, conscience, and association, together with the political liberties. Second, that they honor the rule of law. And third, that they have governments which are limited and so allow for a robust and diverse civil society. I then suggest that the question I raise presses especially hard on those whom I call citizens of ecclesial faith. These are adherents of religions which claim that the human good, the highest human good, consists in a relationship with God that is mediated by a particular ecclesial structure. In the paper, I argue for the claim that citizens of ecclesial faith should value the way liberal societies, so understood, create space for pluralism, the public cultures by which they create that space, and their own participation in the maintenance of those cultures, provided that those public cultures include a crucial ingredient. Now, the key idea in the paper is the familiar one that liberal societies which allow for robust civil society allow for reciprocally checking centers of power. But the ingredient I claim the culture of liberal societies should include gives the familiar idea what I think is an unfamiliar twist. That ingredient is what I call the non-deferential treatment of religion. I now pick up, in medias res, by saying what deferential treatment is. Well, deferential treatment of a church, as I shall understand it, is a form of privilege which does not depend upon the church enjoying a different legal status than any other, nor on religions enjoying a different legal status than other commitments. In that way, it differs from preferential treatment, as I understand it. Deferential treatment has a number of ingredients. One ingredient is the social trust accorded to its hierarchy and clergy. I take the trust in the phrase social trust to refer to a working presumption that those who are the subjects of the attitude act for the good of those in their spiritual care, and that they honor demanding norms of pastoral conduct. In saying that the trust is social, I mean that according such trust is normative or expected of church members, including those in official positions, but also others in society, including members of cultural and political elites who are outside the church. By describing the trust as a working presumption, I mean to signal the fact that not everyone who accords what I have called social trust actually believes that members of the hierarchy and clergy honor the norms to which they're supposed to adhere. Rather, I mean that it's generally understood that those who accord the social trust will act as they would if they believed it. Another ingredient of deferential treatment is that officials and clergy are accorded considerable latitude to act without official or unofficial scrutiny, so that the propriety or legality of their action is rarely called into question. Still another ingredient comes into play when their actions are called into question. When they are, church officials and clergy are accorded a strong presumption of innocence by civil authorities, the gravity of their offenses is minimized, and they are punished with lenience. Where a church receives deferential treatment, it and its hierarchy and its clergy enjoy positions of privilege. The privilege is, in the first instance, a cultural rather than a legal phenomenon, for its maintenance depends upon the general recognition and observance of informal and often tacit norms. Where it prevails, the explanation of its prevalence, like that of other forms of privilege, can be complicated. Those who sustain it may act out of a variety of motives, from the reverent and the high-minded to cold calculations about how best to maintain the goodwill of ecclesiastical officials in positions of political, social, and economic power. Now, I regret that I cannot give a more precise characterization of deferential treatment, but I hope that I've said enough to make the phenomenon recognizable. I also hope that I've said enough to make it plausible that if a church is accorded deferential treatment, then those who hold positions in its hierarchy and clergy can avoid being legally or socially accountable for their conduct. They will not often be subject to legal penalties for offenses they commit, and such offenses will not often be spoken of in ways that open them to shaming or ostracism. Well, those holding official or clerical positions within a church are in positions to exercise power over those entrusted to their care. Adult and minor clergy in training, minors who may be entrusted to their tutelage or supervision, and believers who approach them for pastoral care at vulnerable moments in their lives. If they can escape legal and social accountability for their conduct, then they're not compelled by the threat of legal and social penalties to exercise their power in ways that track the interests of those over whom they exercise it. They may, in fact, exercise it in ways that track those interests, but if so, that is a matter of their goodwill, since there are not sufficiently strong legal and social incentives to do so. That those in positions of ecclesial power are not forced to track the interests of those subject to them leaves the subjects vulnerable to abuse. This vulnerability is therefore traceable to the deferential treatment accorded to churches. If one thinks, as I do, that subjects should not be left vulnerable to the abuse of power, even when that power is not in fact abused, then it follows that churches should not be accorded deferential treatment. To see whether citizens of ecclesial faith should value their participation in a society which does not accord their church deferential treatment, we need to see what the opposite of deferential treatment would be. Now, I think a generalized suspicion of a church, its clergy, and its hierarchy would be a mistake, as would a generalized readiness to believe the worst of anyone who professes a commitment to the forms of sexual discipline and abstinence that a church might ask. What is necessary is that public officials and ordinary citizens sustain legal and cultural practices which provide ecclesiastical officials and clergy with the appropriate disincentives to act against the interests of those in their care and power. The legal practices that are necessary are obvious enough. Statutes of limitations for past offenses need to be lengthy. Officials need vigorously to exercise their subpoena power to investigate first-order crimes and subsequent attempts to conceal them. They cannot be afraid to jail even highly visible officials who are convicted of criminal behavior. But the necessary practices are not just legal, and it's not just public officials who are responsible for maintaining them. Investigative journalists, their editors, and their publishers have to follow stories where they lead. Citizens have to be supportive of them. Everybody must learn to call the crimes what they are. A culture of non-deference makes cognitive and emotional demands of citizens of ecclesial faith that they may find difficult to satisfy. Though how difficult, no doubt, depends upon the internal organization of the ecclesial organizations to which they belong. Suppose that that organization invests its clergy and hierarchy with authority on theological and moral matters. And suppose we follow Raz in thinking that the exercise of authority consists, at least in prominent part, in the provision of preemptive reasons. Then the recognition of clerical or hierarchical authority requires the reception of clerical and hierarchical pronouncements as reasons of that kind for belief and conduct. That is, it requires members of the church to treat those pronouncements as blocking the force of other reasons they have that bear on these matters. Getting them to treat such pronouncements as preemptive, rather than as, say, advisory, is greatly facilitated by formation in a church culture with its account of ecclesial authority's divine source. But that formation can easily encourage habits of deference to authority that are far too general in scope, so that reason, scrutiny, and judgment are short-circuited, even where they are warranted or permitted by the church's own official lights. If citizens of ecclesial faith are to avoid according undue deference of this kind, they have to learn to live with the challenging psychological dualism, at least they may, for they have to learn to treat ecclesial authority as genuine and preemptive in some cases, while confining their deference to its proper sphere. A culture of non-deference makes demands of other citizens as well. Investigators and prosecutors can be overly zealous even in the pursuit of a righteous cause. They need to do their work with judiciousness and restraint. A religiously pluralistic society may well be home to faiths and churches whose practices are strange or off-putting and whose members seem alien. A culture of non-deference also has to be a culture of tolerance, so that minority faiths are not met with unwarranted hostility or suspicion. All this is part of what it is to sustain a liberal society in which there are multiple centers of power, ecclesial and governmental, which can be mutually checking. Citizens of ecclesial faith should value such a society and their own participation in its creation and maintenance. For by doing their part to sustain such a society and its public culture, they participate in creating disincentives for those who would otherwise be in a position to harm vulnerable persons in their care. Well, if we like, we can then follow the argument to its Rawlsian conclusion. It seems clear that one of the things citizens do by sustaining a liberal society with mutually checking centers of power is honor the liberal commitments to freedom of information, conscience and association, to the rule of law, and the existence of civil society. Since citizens of ecclesial faith should value the desire to sustain such a society for the reasons I've given, they should also value a sense of justice informed by those liberal principles. If those principles are demands of right, then even in a non-ideal society, there is some congruence between the right and the good. This congruence will help to stabilize a liberal society, just as Rawls hoped. Well, I'll conclude by considering some objections. The first few objections form a related set. What relates them is this. They seize on the fact that at a crucial juncture in the argument, I moved from a description of deferential treatment to the claim that when a church enjoys such treatment, members of its clergy and hierarchy do not have sufficient incentives to track the interests of those over whom they exercise power. or more precisely, they do not have sufficient disincentives not to do so. That means that they are in a position to dominate those over whom they exercise power, in Philip Pettit's sense of domination. Pettit has famously argued that political relations of domination are morally objectionable because those who are dominated lack an important kind of freedom. The argument I have offered against deferential treatment of churches may be thought to turn on the moral objectionability of domination by clergy and members of the hierarchy. But, it may be said, the claim that Republican freedom should be enjoyed within the organizations of civil society requires considerably more argument than I have supplied. For the freedom to associate in such organizations, which follows from the first and third conditions of liberalism that I laid down, would seem to entail a freedom to associate in all kinds of organizations, including those in which Republican freedom is unavailable. Moreover, the values of political liberalism apply just within the domain of the political. Civil society, by definition, falls outside that domain. To apply the value of non-domination to civil society, as the argument seems to do, is contrary to the spirit of political liberalism. Finally, an argument that turns on the objectionability of domination would seem to be a poison pill for Rawlsians. For Rawlsians seem to privilege a different kind of freedom, namely autonomy, and they seem to privilege the kind of relational equality to which autonomy or reciprocity, rather than Republican freedom, conduces. So the argument may seem to reach what I called its Rawlsian conclusion only by appealing at a crucial juncture to the value of a non-Rawlsian conception of freedom. I think all of these objections misfire in two ways, or I'm not quite sure how to extend the metaphor of misfiring, two directions, two ways. The first way in which they misfire is by mistaking the crucial step of the argument I've offered. It may well be that when churches receive deferential treatment, clergy and members of the hierarchy are in a position to dominate those in their care. But the argument against according them such treatment does not turn on the moral objectionability of domination. It turns instead on the need to provide those who are in vulnerable positions with security and to protect them from what are uncontroversial bads. The argument does not appeal to controversial claims about Republican freedom, nor does it appeal to controversial claims about proper relations within civil society. The second and more interesting way in which the objections misfire is in assuming that freedom as non-domination is alien to Rawls's view or to contract theory. I don't think the assumption is warranted, though I can't argue for the claim here, mostly because I don't quite have an argument for it. I think Rawlsians can accord non-domination a place in a theory of justice, even if it's a subordinate one. So I think they can claim that freedom from domination is one of the goods that falls out of a state of affairs in which basic institutions conform to principles we would give ourselves, and in which their conformity is supported by a public culture that includes non-deferential treatment of religion. A different objection is that the argument appeals to a false dichotomy, for it assumes that the only way to protect the vulnerable is by a culture of non-deferential treatment. Another possibility, which I did not consider even to rebut, is to leave deferential treatment in place while letting the organizations of civil society police themselves. Why, it may be said, is that not an acceptable way to provide security and protection? Well, the claim that a culture of deferential treatment leads to unacceptable vulnerability is an empirical one. The question of whether ecclesial organizations can adequately police themselves is also empirical. The short answer to it is that the results of the empirical investigation are in, especially with respect to my own church in the city just across the river. And we know all too well how self-policing worked out. According to a more expansive version of the foregoing answer, things have worked out that way because societies in which deferential treatment is accorded are precisely the ones in which the organizations of civil society are likely to be especially bad at policing themselves. There are, I think, many reasons why this should be so, and I shall cite just one: the way in which privilege and deference shape an institution's self-conception. I conjecture that once an organization has become accustomed to privilege, it becomes very hard for it, read those who direct it, to think of itself as lacking privilege. It becomes very difficult for it to conceive of itself as living on the social margins, even if that's where its true mission lies. And so the privilege that is accorded when it is deferred to comes, over time, to be thought of not just as the way things should be, but as the way they must be, as essential to its identity. Once a privileged status is seen as an essential component of institutional identity, that status has to be protected, even at very high cost. That means that much of what threatens to jeopardize the privilege is going to be suppressed, covered up, or silenced. If this empirical conjecture is right, it's one more reason to object to the deferential treatment of religion, and one more reason for citizens of ecclesial faith to value their own participation in a culture which refuses to accord it. Thank you.
It's a pleasure to be on this panel and to be in this room with these people. Michael, thank you for the invitation, and I'm particularly grateful to Ludek for the work that he's done to make this occasion possible. I'm going to talk a little bit about religious contributions to political debate, which has some connection with what Andrew said and has a different sort of connection with what Paul said, but mostly it's going to be, if you like, a criticism of some of the themes of political liberalism. So here goes. In March 2007, an American organization called Evangelicals Against Torture issued a document entitled an Evangelical Declaration Against Torture. Excuse me, they were Evangelicals for Human Rights. They issued a document, a Evangelical Declaration of Torture, and on a slow afternoon they managed to get the National Association of Evangelicals, which is a white evangelical organization, to pass this. Yes, maybe I'll bring the microphone closer to me. Right. So they managed to get this declaration passed as a contribution to the national debate about the treatment of detainees in the war against terrorism. In it, the authors said that, this is a quote, "When torture is employed by a state, that act communicates to the world that human lives are not sacred." They added that this is a claim that no one who confesses Christ as Lord can accept. They went on, "The incarnation, that is of God and Jesus Christ, signifies a mysterious bridging of the gap between God and humanity. Henceforth, the human experience in its joys and sorrows is inscribed upon the very person of God. The Holy Spirit participates in human pathos with groans and sighs too deep for words. The cries of the tortured are in a very real sense the cries of the Spirit." And it went on in this vein for 20 pages or more. The conclusion of the declaration was uncompromising, as you would expect. We renounce the use of torture by any branch of our government, even in the current circumstance of a war between the United States and various radical terrorist groups. Now, the evangelicals addressed these sentiments to political leaders, especially in the White House, but also to their fellow citizens to whom those leaders would be accountable. And in this way, they added a certain amount of weight and moral seriousness to the debate about torture that we had to have in the years following 9/11, a debate that in some circles, as you know, continues to this day. So here's the question. The passages I've quoted from the Evangelical Declaration embrace a dense and challenging array of religious ideas and religious rhetoric. And as I said, it goes on for pages. In a democracy where there are people of different faiths and many who have no religious convictions whatsoever, is it actually appropriate for a group of citizens to invoke ideas like these about the consecrated sanctity of the human person, the cries of the Holy Spirit, the desecration of God's image, and so on, in making arguments, public arguments about counterterrorism policy? So far as many of their fellow citizens are concerned, the authors might as well speak in Latin. Some of them actually do speak in Latin. Or they might be speaking about Middle Earth and the voices of elves and pixies. can this possibly be regarded as a respectful contribution, a civil contribution, a reasonable contribution to dialogue in our political community? These are the questions that I want to ask. Should we be talking to one another in public debate with words of this theological or metaphysical heft? Does such talk satisfy reasonable demands of political civility and reciprocity and reasonableness? In itself, the position taken by the evangelicals, their suggestion, is an attractive one, or at least it is to me. But shouldn't the members of the group have found a way to express their views in secular terms that would have been accessible to their fellow citizens? Now, these questions are associated, as you know, with John Rawls's later work and a school of thought that Rawls inspired called political liberalism. That school of thought sponsors a largely negative answer to questions about the appropriateness of offering religious considerations in public debate. In discussing constitutional essentials and matters of basic justice, and torture is certainly a matter of basic justice, said Rawls, we're not to appeal to comprehensive religious or philosophical doctrines. It said that public justification cannot depend upon premises held only by some sections of the public or upon doctrines intelligible to some citizens but not others. The evangelical declaration may represent the ultimate truth about torture in the eyes of its authors, but according to Rawls, the zeal to embody the whole truth in politics is incompatible with the idea of public reason that belongs with democratic citizen. I hasten to add that I'm not attributing to him any desire to actually censor or restrict contributions of this sort. The idea is that we should feel more than usually awkward about expressing them, and such awkwardness should reflect some inhibitions about civility, inhibitions about reasonableness, and inhibitions about reciprocity. These suggestions by Rawls have had a large and widespread influence, sponsored in part, of course, by the immense prominence of his work elsewhere in political philosophy, in his theory of justice. Relative to that body of work, as Robert Nozick said in Anarchy, State, and Utopia, people must now work within Rawls's framework or explain why not. But the stuff about public reason and the inhibitions Rawls thinks it ought to generate on our reason-giving in politics is a thesis in democratic theory, and there Rawls's work has less of a prior claim on us. I don't believe his later work has established itself as any sort of default position, or even if some political liberals treat it as such, I shall not. So how to answer this question of whether these contributions are appropriate in political dialogue? I want to, as it were, go back to first principles on that. And that's difficult because despite the enormous amount of democratic theory that there is in the philosophical world, we're not yet in position of a rich, textured, realistic, normative account of what it is that people say and ought to say and should think of themselves as saying, and what sort of influence they should think of themselves as exercising on one another in political debate. And I can't do much on this in 25 minutes, but I'm going to try to spell out a few ideas about this. I began with this real-world example about torture and the evangelical declaration just because I wanted to break up some of the abstraction, even the scholastic abstraction, of the way the political liberalism material is set out as a self-contained body of abstract ideas about justification, legitimacy, and public reason. I think the plausibility of the political liberalist position is better assessed when we break up that self-contained logic with a concrete illustration. And if we can match a real-world illustration to a rich and realistic account of democratic participation, so much the better. Sharpen the issue just a little bit more by imagining that the evangelicals have made their intervention and they are confronted by another group of people who make largely pragmatic arguments in favor of torture, in favor of coercive interrogation, as many people did in the years after 9/11. They said in order to save large numbers of lives in this country and elsewhere, we need coercively to interrogate some of the detainees, and we do it because we value human life. They speak just in those terms, and those terms are not only intelligible to the speakers, but they are intelligible to the audience, including the evangelicals can understand them. But the pragmatist guys can't understand a word of what the evangelicals are saying, so there is this asymmetry, or this apparent asymmetry of understanding, and that, I think, is a good way of capturing the worry or the concern about reciprocity that is involved in this matter. So how to think about what we're doing when we talk to one another in politics? The first thing to say is that when we participate in politics, we are disclosing ourselves to our fellow citizens. We are saying who we are. There's a lot to be revealed. Citizens are not just ciphers or potential votes with names attached. Each person has a series of political positions, more or less stable, more or less well thought through, the product of their experiences and their training and their education. Each of them is positioned in a certain way philosophically and ideologically. Each of us has been made angry by some things, lifted up by certain possibilities, traumatized by things we have seen as abominations. We put on display for others in our speech a political sensibility informed in all these ways. We bear witness to our commitments and experiences. There's a connection, I think, and it's important in this regard, between this self-disclosure and the idea of reasonableness. We are reasonable when we are ready to reckon with the presence and the interests of others in politics, to take others into account. But it's not just taking others into account under any old description. We have to be ready and willing to reckon with others as we are, and we pay attention to their self-disclosure to find out what, in their case, we have to reckon with. I'll come back to this point about reasonableness a little bit later, but I'm suggesting that when we talk to one another in politics, we try to disclose who we are, not just as a matter of self-expression, but we disclose who we are in order to make sure that others know what the demand of reasonableness on their own conduct is going to be. We should be we have no choice but to disclose ourselves in this way, because people don't begin in a modern polity, even in a well-ordered society, by being transparent to one another. A democracy of any size is necessarily a society of strangers, and mutual intelligibility has to be built up. It's not given. Any recognition we secure for ourselves from others as part of this reciprocal reasonableness is a result of communicating to them how our background, hopes and fears and experiences underpin positions that we publicly espouse and relate to positions that they have in their experiences and their hopes and fears and so on. And we should be under no illusion that this disclosure can secure total transparency. It's bound to be partial, often somewhat distorted, but we build for each other reciprocally a rough sense of the sort of person we are, so that others can say of me, oh, that's where Jeremy is coming from on this issue. Well, that's why this matters to him so much. You mightn't have known that in advance, but you listen. And I listen to my fellow citizens and work out where their concerns are as well. Reciprocity does not require that the ease or difficulty of understanding each other should be exactly the same. It means that we each make this offer of understanding and reciprocate it, and we make this offer of being understood in relation to what is at stake in our politics. And I emphasize that we don't come in just in a sense of political roles that are given by an external script. It is we who are involved, we who have constructed this politics for ourselves, we who have constructed a sense of legitimacy and decisional mechanisms and deliberation. We set up and argue for democracy against the background of us working together to find out who we are, to share a common sense of that, and then try to resolve our disagreements in relation to that background. Not only is each person's self-presentation to others partial and incomplete, people aren't even necessarily transparent to themselves. As a citizen, each of us is a work in progress. Our views are not fully formed in advance of each debate. Often we form them in the context of thinking alone or thinking together about the issues that we face. Experimenting with different forms of self-disclosure and engagement may deepen the views we hold or our understanding of the views we hold. I didn't know as much about my views on torture until around 2005, and this has nothing to do with the Evangelical Declaration, when I attended a meeting at the Princeton Theological Seminary, a meeting of an organization branded temporarily as Church Folks Against Torture. And just beginning to speak up at that meeting, you begin to find out what you believe, and at the same time you're beginning to disclose that to others. And people's views and positions are often ill-organized by logical standards. Political liberals make much of the distinction between foundational and justificatory positions, and foundational and justificatory disagreements that arise out of them. But things are not usually so tidy, with a determinate set of foundations and then a steady logical progression to the theorems of the position. What's a foundation in some contexts may be a flying buttress in others. And we disclose different parts of our position at different stages when it seems desirable, and our arguments have impact in untidy ways. Who knows what part of our presentation brings about a change of heart or just transforms a little bit the understanding of those who listen to us. If our views are religious in flavor, that doesn't necessarily mean that, I don't know, that we begin with Jesus and then build up an adamantine structure, smooth and inaccessible to any non-believer on that basis. You know, things may add up to a belief in Jesus, or there may be multiple points of access in an untidy series of beliefs, and we communicating this to others is not just a matter of disclosing oneself, it's attempting to have some bearing on others' views, which may be a small bearing or a large bearing, a complex bearing or a simple bearing in political debate. We do this, we don't do it in a vacuum. We do it against the background of civilizational resources by which people can try to get some means to access each other's views. So I don't know, the evangelicals against torture talk about the Holy Spirit, and somebody says, what's all this about the Holy Spirit? Well, the society is groaning with libraries and museums and theology faculties that can be accessed to give people some way of understanding what they see and what they hear from other people's interventions. Non-religious folks say, why should we waste our time doing that? Why should we waste our time doing that any more than trying to investigate the nature of the views of L. Ron Hubbard or the views of the Social Credit Party? And that's a perfectly reasonable response. People have limited time and limited resources. And many people don't want to be seen as taking seriously religious ideas, and that's maybe reasonable as well. Only now what is being said is that people may have a reason not to try to understand these ideas, rather than that it's uncivil to put these ideas into play at all. We all respond to others' engagements in a variety of ways. We disclose ourselves and our position publicly to others in order to engage with one another, eventually in order to vote. And what's important is reciprocal engagement as people take on board what they can of others' viewpoints, answer them, dismiss them, sometimes looking for common ground or searching for new ground, sometimes attempting to help others in these tasks. Think of it in this way, we say. Yeah? Maybe we can't convince people of the detail of the evangelical declaration of torture, but that some people in the community are regarding torture in this light may be an indication that this is not just, as it were, a routine question of public policy. Some people are bearing witness to the notion that this is an abomination of some sort, and that can have its impact. And there's an awful lot of space for impact in between complete rejection and complete adoption of the position that you're hearing. Let me add this further element to the picture. The issues we're talking about are not a game, they're important. And they're important because of persons, because we are putting forward our views about how persons should be treated, whether it's a matter of justice, a matter of rights, whether it's this issue of torture. We're talking about humans and their dignity, humans and their prospects, people who may be killed or gravely hurt by what is being proposed, whose dignity may be slighted or respected, whose interests may or may not be served. So that although we are disclosing ourselves when we engage in political participation, we are disclosing ourselves on the subject of others. We are disclosing ourselves on the subject of others. We're not just talking about dilapidated houses or polluted lakes. We're talking about humans. And we're attempting to characterize the nature, the status, and the predicament of certain humans, which we think needs to be taken seriously. And that, I think, goes again to the issue of reasonableness. because it's important in our politics that we reckon with others, some of whom cannot speak for themselves. It's important in politics that we reckon with others' interests and others' well-being, and sometimes that reckoning can only happen pursuant to an account that somebody else gives. So we need to listen to what is being said in our community, not just in order to reckon reasonably with the speaker, but reckon reasonably with the people whom the speaker is describing. It's tempting to say that the constraints of public reason are irksome to us, or some of us, as political actors. They look as though they're trying to make the evangelicals awkward, or they're trying to make Waldron feel bad, and to leave him tongue-tied, to dissemble about the true grounds of our beliefs. And the complaint might seem to be that this is unfair to the speakers, to the people who are trying to articulate the religious considerations. But that's not right, or at least it's not true, wholly true. If the reasons which are excluded really are morally significant reasons, then the complaint about their exclusion should be a complaint at least partly on behalf of the interests and the considerations that the reasons draw attention to. The complaint in the case of if we were to try to make the evangelicals feel awkward, try to inhibit them against introducing what they want to say about torture, then the affront is not just to them, the affront is to the victims of torture who cannot have their position described in this way. We'll take another example. In Dred Scott against Sanford, the case in the 1850s, Justice John Maclean, in his dissent, thought it important to mention that the plaintiff should not be regarded as a potential chattel, as a slave. He should be regarded as a person entitled to justice because, and this is a quotation, he bears the impress of his maker and he is destined to an endless existence. Now, Maclean violated Rawls's constraints on public reason. He did so in the very institutional setting that's supposed to be an exemplar of its operation. A Rawlsian insistence that considerations like this should be excluded from public reason may seem to those who disagree with Rawls as an affront to Justice Maclean, but the real affront is to Dred Scott, whose ethical and metaphysical status cannot be mentioned in this way in a decision about his potential citizenship. Because this reason cannot be mentioned, it may seem more likely that he'll continue to be treated as a chattel rather than as a person, because the weight of the reasons that there are for treating him as a person, it may not be adequately conveyed. So this is the basis of the complaint about the public reason exclusion in this case, that it leads us to treat Mr. Scott badly, not that it leads us to treat Justice Maclean badly. And the fact is that the subject matter of what is spoken about is important from the point of view of reasonableness, just as the speaking itself is important from the point of view of reasonableness. It's about the reciprocal concern we are to show for one another, and which is to be shown for all who are affected by our decisions. And some of that concern doesn't come out of nowhere. It's not given in a philosophical book. It has to be articulated, given voice, become common ground among us. If each person is to be considered and taken seriously as a subject of public policy, that concern has to be articulated and voiced. If people are being treated as objects or being treated as animals, somebody else has to be able to stand up and say, in the appropriate tone of outrage, this is a woman, or this is a man. Or as Aaron Barak insisted in Israel's High Court of Justice in the 2005 targeted killing case, without prejudice to the outcome of the case, the targets, the terrorists who might be killed, are created in the image of God and have human dignity on that basis. And he said that not to settle the matter, but to make sure that the matter was being discussed with the appropriate seriousness. Now, other justices, such as Justice Beinisch, found other ways of saying the same thing, and there's a multiplicity of different ways. Barak thought it was important to say this in those tones and with that degree of seriousness, so that people would not take lightly the question of what to do with these evildoers, not treat them just as though they were good animals gone bad, but persons guilty of wrongdoing. In a democracy, I think the default position surely is that citizens have to feel free to state their views candidly, to call things as they see them, to disclose themselves to others as they are. The understanding of their positions will be partial, but there will be attempts at understanding by some people and not by others. The understandings of their views may be partial, and it will, as I insisted, not be reciprocal in the sense of my ease of understanding your position is matched by your ease of understanding my position. They may be more or less easy, but we don't want to head towards the lowest common denominator on these matters. I do want to say that democracy is, in a way, it's a sort of a come as you are and disclose as you are system. We don't have to pretend to be other than we are in our participation in politics. There are no deplorables in that sense. We have to be able to convey, if we're talking about our own interests, how important we think those interests are, usually relative to a matrix of similarly important interests, which is a background assumption of this self-presentation. Or if we're talking about other people's interests, we have to be able to convey the importance of that as well. So I do think the burden on any political liberal position to try to inhibit the basis on which people talk to one another is very large given this background democratic ethos. Rawls and others have thought that considerations about access, considerations about civility, considerations about reasonableness, and considerations about reciprocity discharge that burden. I've tried to argue very briefly this afternoon that they don't, or that there's a case for being skeptical about whether they discharge that burden. But the main drift of my comments today is that we do need to ground anything we say about public reason in a vivid and respectful account from democratic theory of what political participation on matters of basic justice and constitutional essentials actually involves. I think it has to be a little bit less abstract than the characteristic presentation of political liberals. It must honor people's construction of themselves as political animals and their sense of the issues and their sense of the understanding of the people who, in a way, are the issues in any discussion of basic justice or constitutional essentials. And it must honor the complex and untidy ways in which people's views are formed and articulated and in which they engage with one another. Engagement, learning about and from each other is always partial. That's the essence of political life, and we shouldn't be in the business of trying to pretend otherwise. I'm sorry these considerations have been presented in this sort of dogmatic fashion. I did want to be respectful to the Rawlsian position, but indicate how vehemently I feel about the question of the inhibitions of public reason. Thank you very much indeed.
So we have a good 45 minutes for Q&A. And before opening thumbs up, I was asked maybe to start things off. And Samuel Scheffler in the last panel asked what happened to all the justice talk in the 60s and 70s. And I think the sad answer was they got rich. Another sad answer, I think picking up on Katrina Forster's emphasis on our historical distance from Rawls by my lights, is that the political coalition of the religious and secular left in public culture, but often grounded in universities, even like this one, broke apart sometime in the 1970s and has never been put back together. There's lots of historical and sociological reasons for that, as much as epistemic ones. And maybe Rawls in some ways embodies that shift in his personal biography that Kenzie talked about. But in many segments of the academy today and public culture, he's blamed for it. To the extent that Rawlsian liberalism, maybe outside the guild of political theory, is seen as prone to capture by neoliberal technocracy, and that Rawls and Rawlsians are seen as hostile to religion itself, given the scholasticism of the idea of public reason as an anemic way of thinking about power, authority, and civic virtue. In short, Rawls, or at least Rawlsians, not only fail the publicity condition, but they are said to exacerbate the culture wars rather than transcend them. Now, I haven't read Rawls in Tunis, but I've read Rawls with plenty of evangelicals, Catholics, and Muslims in Princeton, but also many non-elite colleges around the country. And it's shocking to me how they see Rawls as tone deaf to their concerns and their identity, despite their desire to change their own religious traditions in support of the American experiment and a more participatory democracy, often for progressive political causes. Now, this risks nostalgia, not to mention resentment, but I just thought I would sort of register this as a kind of amateur historical observation. There's also been a resurgent interest in political theology in the broader humanities that largely neglects Rawls or claims him as the boogeyman. The irony, perhaps, of this conference so far is that the opening panel on the project of modern political philosophy had more theology than a panel on religion and democratic society. That panel, to caricature, I thought raised issues of the political from the perspective of the religious, or its secular analogs. Our panel has been more about issues of religion from the perspective of the political in a pluralist society or democratic theory. And just the one thread I heard throughout was this kind of fact of reasonable pluralism. And I can't cite chapter and verse, but I was thinking about the passage in Rawls that I think he talks about Isaiah Berlin and the notion of inescapable social loss, or the loss of social worlds even within egalitarian liberalism. It's hard to be Amish in a modern America. It's hard to celebrate liberal society, maybe without experiencing diversity as a great good. It may be hard to enjoy certain goods of Islamic piety in an Islamic democracy. So I thought I would just ask how each of you, or if you want to pick this up, this kind of more tragic Rawls, the sense that for all the goods of egalitarian liberalism, there may be a loss of forms of life that are not intrinsically unjust, perhaps ones that don't take up the view that the role of citizen is part of the good life or a sense of worth, or ones that for whatever reason are difficult to express in a well-ordered constitutional democracy under conditions of modernity and the rise of science, et cetera, et cetera. This might be a broader interpretive issue about the early so-called Kantian Rawls, theoretical abstract, and the more Hegelian, later historically embodied Rawls. I don't know, but it was just sort of this notion of kind of the tragedy of liberal democracy and how we come to reckon with that as committed maybe to that project. And you know, this sort of, I think, also, I'm in a religious studies department where sometimes I feel all we ever do is talk about the category of religion as an invented category. What is religion? But you know, how religion might be special in this context of thinking about tragedy. Is there something about religion more broadly that's a human good that warrants some type of deference or concern? Religion has sort of been in the air. We've been talking about self-respect and shame and guilt, all that religious traditions talk about. So sort of reasonable pluralism, tragedy, and the specialness of religion. 30 seconds each as the...
Which order?
Shall I say
whoever
something
wants
about
to.
this?
Our way down the table.
Because I didn't want to deal with this theme at all, nor to blame Rawls for any particular thing happening to religion, but simply to contest these specific arguments about access and civility and reasonableness and reciprocity. It does seem to me that there is all over Rawls's political liberalism an acknowledgement that none of this is saying that religious reasons are not real reasons, or that religious truths are not real truths, or that there's anything disreputable about grounding one's own personal convictions on religious ideas. It's not intended in that sense to denigrate religion, and I think that that's an acknowledgement that religious organizations are not just clubs, and religious beliefs are not just hobbies. They are where people form some of the deepest possible convictions about the value of each other's lives and the nature of respect between persons. So I think it's very important not to oversell this critique that I was putting forward this afternoon. It was a specific response to a specific set of arguments that I thought were in danger of becoming too current and too widely accepted. But their acceptance had more to do with political philosophy than with any malaise about religion.
But you accept the notion there are religious reasons and there are non-religious reasons?
Well, there is an array of reasons, but they are reasons about the same thing.
Right.
Yeah, the religious reasons about human rights and non-religious reasons about human rights. There are religious reasons about justice. You know, the prophets spoke of little else. There are non-religious reasons about justice. Part of what I wanted to say this morning in response in a question to Sam is that we get our sense of how important justice might be from listening to prophetic talk about justice rather than analytic talk about justice.
Let me just say three things, two in response to you, but one preliminary item, and that is that since we were talking about civility, everybody who has spoken here has honored a dictate of civility that I failed to honor in my own talk, which is to thank the organizers. I even had a note to myself to do that. Not supposed to need them. So again, thanks very much for organizing this and especially for inviting me. 2 points in response to what you said, Eric. One is about the fact that there is no social gain without social loss. I mean, it is, I think, important that Rawls acknowledge that, but societies are never in stasis because people are never in stasis. And if there's one thing we learn from Rawls, one really powerful lesson he's taught among many, it's that human beings are naturally disagreeing animals. It's natural to us to come up with different ideas about things, and coming up with different ideas about things means that society is going to change. And that's as true of conservative societies as it is of liberal ones. People are going to come up with different ways of living out their traditions, living out their ethnicities, living out their religions. And that means that there's always going to be loss. And not only are we innovating beings, but we're also beings who are attached to our past. And some people at least are going to experience the loss quite deeply. I think that's just a natural thing. I think it's inescapable. Third thing is that we should not infer from the kind of losses that our society has incurred anything about the kind of losses that I think might be experienced or incurred by a well-ordered society. Whether or not Rawls has been captured by neoliberalism, we live in a society that has been dominated by it in recent decades. And that, I think, is quite different from the society in which that Rawls envisions. He may well be regularly misunderstood as an advocate of neoliberalism of some kind. I do not know what more he could do, especially in his latest works, to distance himself from that than he did.
I have three very quick points. I can't imagine how anybody, insofar as religious ways of life are being lost, I can't imagine how somebody could think that it was due to a book published in 1993 as opposed to capitalism, social changes, the market, everything else like that. Two, I think we should also not forget that, I don't know if we have a token sort of perfectionist here these 3 days, but political liberalism is also seen as a tragic loss of certain kinds of non-religious, perfectionist, Enlightenment, Marxist hopes of emancipation, right? And so, very often this is the whole debate over whether debate with Habermas and the debate with others, whether it's a principled theory or itself a compromise, that it goes too far and recognize religion as reasonable, comprehensive doctrines. And third, who says religious ways of life are being lost? They're all around us and growing.
Okay. Should I go from the left to the right or the right to the left? Maybe I'll go from the left to the right. And the first question down here, Professor Korsgaard. I think there's a mic coming that they...
to you, Christine.
Chris Korsgaard for Jeremy. I'm wondering if you might want to distinguish two different ways in which someone might enter a discussion religiously. One being just kind of asserting, this is how it is according to my God or according to my faith.
Yeah.
And the other being some kind of spelling out how it is according to their God and their faith, together with some effort to show how this represents common ground with other positions so that they can at least be seen as attempting to achieve something like an overlapping consensus. I think maybe you stack the decks a little bit using torture as your example.
Right.
So I'm thinking, for instance, of a debate over the right to choose the moment of your own death if you're ill with a painful, fatal illness. And if somebody just says, not up to you when you die, up to God when you die, I feel as an atheist that this person has not said anything to me that I have any way of listening to. And if there's some spelling out over what this represents about control or nature or who knows what. So, and I want to say, if it's the first thing, if you mean the first thing should be allowed, you're wrong. And if you mean the second thing should be allowed, isn't isn't that person already sort of meeting Rawls's standard of public reason?
Yeah, yeah. It depends, Chris. I mean, obviously it's going to be a difference of degree in two dimensions. One is that as you adamantly say, well, my God doesn't allow this, full stop, you may or may not festoon that with one or two hints as to where and why and how and who. And the other is people often intervene and say, my religion doesn't allow this. And they say, for further elaboration, talk to the bishop. So there's a certain degree of normative deference to others. But let's assume that it's a matter of degree. And then the further question would be, as the person spells out their view, are they spelling it out in largely secular terms, or are they spelling it out in subordinate religious terms, giving it some religious texture or giving it some general philosophical texture, or as is most likely, both? And the more spelling out that there is, then the more we face the phenomenon that I tried to present, that there are points of access, or there are points that people can get hold of. But even if there's less spelling out, you learn something from the fact that somebody takes this very, very seriously. Indeed, that this is not a light matter when they speak of it in religious tones. So that's the only reason I would feel self-consciously pushing back against your suggestion that if it's number one, then Waldron's wrong, and if it's number two, then Rawls is right. And I do think sometimes the spelling out can be itself in religious terms. And as you spell out for the view for the following religious reasons, 1, 2, 3, 4, 5, 2 and 5 might have tiny little bits of resonance for some of the people in your audience because they remember these, or 3 and 4 might be things that can be more or less easily translated into religious language.
Just as a follow-up, sure you learned something, but this person is not supposed to be just testifying or witnessing or demonstrating his own identity. He's supposed to be communicating with you. So it's not enough, I think, that you learn something any old way you might learn it.
Yeah.
You should learn something that he's sort of addressing to you as the thing to be learned. This is to be respectful dialogue.
Right, right. But again, remember the complexity that may present. It may be that in order to find out what he's trying to pursue, trying to communicate to you, as you would if he were a high-level economist, you might have to go away and read something. And you can't say, well, that's appropriate in the economist, but not for the believer. I'm not going to go away and read anything. Or that may be perfectly reasonable, but then it's hardly he who is being uncivil in the argument. And sometimes, I mean, politics is a complicated business. People sometimes speak out because they want to bear witness to something. People sometimes, I mean, it's not unheard of for people to be talking to the choir in political life. There are all sorts of different speech acts going on. It's not just didactic, educational, deliberative in that sense. There's going to be a combination, and any particular intervention will have, I think, multiple facets in the kind of speech act that it is.
Can I add one thing? I'm probably more I'm certainly more with Chris than with you, I think, sorry. But I do think it's worth calling attention to one thing in which your work is, one of many things in which your work has been very valuable, but on this point particularly, and that is that whatever public reason requires, it's not translation. And you've said that from the very beginning, I think, when you had a piece in 1993 in which you talked about public reason. I think it comes up in the Locke book. Religious reasons are going to resist translation, and public reasons aren't going to be translated. Just as there may be no social progress without loss, there's no public reason without loss of some important content. So whatever it is that public reason asks of us, it's not just that we translate, though that language is all too often used in the discussion.
And sometimes used quite honorably, for example, in Habermas's comments on this. Yeah.
Maybe in the way back, if you could bring, there's just one bibliographic note. I don't know how many people know John Shields. I think he's a political scientist. He wrote an interesting book called The Democratic Virtues of the Christian Right, which was an empirical study of the language of Christian right organizations in American politics. And he actually, to his surprise, thought that most of their arguments were couched in public reason terms. Not, obviously, we know lots of examples of, in the background culture, people who, this is what the Bible says and I believe it, but he thought that actually our politics is not like that. In the way back.
Hi, it's Mazia Asghari Tariqi. Question for Andrew March.
Could you speak up a little? I'm sorry, we can't hear.
Yeah, sorry. Question for Andrew March. I was wondering, what does Al-Ghanouchi think about traditional Muslims who believe in Islamic human rights? in his country.
I'm sorry, what about church Muslims who believe in Islamic human rights?
Yes, rather than, as opposed to his own, non-Islamic human rights that you mentioned.
Okay. So I think what you're asking, may I, if I can try to paraphrase, you can tell me if I'm
Yeah.
wrong, that I gave a presentation where he accepted the Constitution's description of human rights as universal because it's acceptable from an Islamic standpoint to see them as human values, and whatever is human, that Muslims should accept it. And so you're asking, well, what about people that are more conservative and want to draw the line in Islamic human rights?
Yeah.
Is that the right question? Is that, okay. So I think, so he is, to use Rawlsian terms, he is very often political in both the right way and the wrong way. So he is as much an intellectual as he is a politician, and much a politician as he is an intellectual. And both intellectually and politically, he goes to the greatest possible extent to avoid alienating people. And this can lead to a certain sense of, well, what is the actual core of what he believes, right? So he will both say to very, very conservative Muslims that that he acknowledges and has something in common with them, but may also do the same thing with very, very conservative people. I think the best way that I can make sense of it in a principled way, and this is what I'm most interested in at the moment, is the way in which after the 20th century, a lot of Islamist political thinkers are looking beyond the state and beyond the conception of sovereignty. So one way, instead of seeing that you have this sovereign political space that has to be governed either by secularism or by Islam, that part of the point is to create, what was the expression again? A social union of social unions, right? That kind of thought, without being prompted, he says, well, we've experienced state repression. We've experienced religion being taken over by the state. What we now think the state should be doing is creating the space for as many different social worlds to be able to live. And if that means some people are drinking alcohol and wearing bikinis on the beach, but some people are resurrecting very traditional Islamic sciences, that this has a precedent in Islamic history, that he thinks that 9th century Baghdad had something like this, but that it's also, I think it's a more profound way of looking at power, that the state shouldn't be everything, but it should be creating a society in which different ways of life can flourish. So I think he would say, yes, we have this Islamic tradition, it's very rich, and we should not let go of it, but we should also recognize the realities of politics given diversity.
As a good Democrat, I'm conscious that there's a lot of voices that want to come in. So can I encourage you in your questions to be pithy, profound, and most of all brief, and then our commentators as well. So we're gonna, there's two here, and then I've noticed several here and here. So I have a list of the ones I know, but I'm gonna be conscious of ones I don't know first here. Yes, in the vest, and then the one in front.
Okay, thank you. I'm Richard Fallon, Harvard Law School. I have a question for Jeremy. One of the things that was striking to me, Jeremy, was the way you drew a distinction between liberal political theory, where Rawls is canonical, and what you call democratic theory, where you didn't think the Rawlsian position had any particular canonical status. And so my question is about how that plays out in terms of some other issues, including the one that Chris Korsgaard was raising. As I understand it, liberal political theory in the Rawlsian tradition is about justification and about the way, with the ideal of justifying the exercise of political power in a way that is accessible to everybody. Democratic theory, you describe it as come as you are, self-disclosure, I assume honest self-disclosure. It seems more in the tradition of rhetoric, trying to persuade people, use whatever rhetoric is most effective in communicating who I am. But the way you've described it so far, it doesn't sound at all in terms of justification, unless the mere fact that there are enough votes for it counts as justification all by itself. And so I just wondered if you could talk a little bit more about that distinction and about whether public justification, in your view, ought to matter more for the people who have the ultimate authority to rule in the name of the state, such as the justices in Dred Scott.
Could I just collect this second question too, so that we could kind of move things quick, conscious of time? Yep.
Martin Palouš, I'm from the Czech Republic, but teaching in Florida. Hannah Arendt, in Human Condition, makes a very important distinction between two fundamental human powers. One is power focused on the future, which is unpredictable. It is the power to make promises and to keep promises. And more importantly here, human power as far as the past, that is irreversible and cannot be undone. And it is the power to forgive. And Hannah Arendt makes a beautiful distinction between what and who. What happened is given a less preference than who has done that. That person with faith is to be released from the consequences of the past so that both can have a free future. I think churches or religions have occupied this territory of business of forgiveness and reconciliations in their traditional contexts. And they are very often happy only when a person forgiven finds the place within their religious community. They don't usually release easily people back to the world where they are. So my question is, would you find that Arendtian perspective important in the Rawlsian discussion on justice? Because justice is one thing, but forgiveness and reconciliation, very important in the process of democratic transition, is another one. So I would like to hear your opinion.
So maybe Jeremy on justification, and if either of you want to say anything on democratic rituals of forgiveness and reconciliation.
Sure. So just in response to Dick's question, and of course we assume that we know what justification is in politics, and I mean real politics, not just here. Justification involves giving and presenting reasons. It involves characterizing what's at stake in an issue and making sure that the issue is taken with sufficient seriousness. And there's a relationship between justification and persuasion. And in a good sense, rhetoric may be involved in what is actually said in the way of justification and persuasion. And I would emphasize what I said a moment ago about it's important not just that one adduce reasons in favor of a particular prescription, but that as a prelude to that, one characterize what's at stake. And that's what Justice Barak was doing in the targeted killing case. You know, it was a prelude. He said there are two important premises of my discussion. Terrorism poses an existential threat to the people and state of Israel. And the second position is the terrorist is created in the image of God, same as anyone else. Yeah? And it was just setting up the decision so that any subsequent justificatory discourse was important. So let's not work with too narrow a notion of justification. And sometimes I think, as in the case of the Dred Scott example or the targeted killing case in Israel, it's important for judges to be able to show in various ways that they take seriously the nature of the issue before them, even before they get to the merits. I think on the forgiveness possibility that it's one of the remarkable features of the modern world ever since the transition from apartheid South Africa that we have thought about truth, reconciliation, forgiveness, or that we think about Willy Brandt sinking to his knees at Auschwitz. We think about these issues of humility and forgiveness as being now part of political practice. We think about apology as part of political practice. And I mean, I'm second to nobody in my admiration for the great Hannah Arendt, but I would part company from her in an instant if I thought she was saying that this is inappropriate in the realm of the political.
Eric Nelson, sorry, and then we'll come down this row.
Hi, I had a question for Jeremy as well, mostly because I'm very much, as he knows, in sympathy with his view. I wanted to say something potentially irenic as between you and the sort of Rawlsian position, and which is by way of a query of exactly how far apart you will be in practice some of the time. And this really has to do with this category of a religious reason. You know, sort of what is a religious reason in the examples that you give, and I found myself thinking about the sort of the example that you gave in the evangelical pamphlet, right? So if you're a sort of rationalist about your religion, or if your God is a rationalist God who acts for moral reasons, right? Then presumably, if you believe in the incarnation, you think that the incarnation took place for non-arbitrary moral reasons. That is to say, there's some set of facts about human beings that made them worthy of this kind of respect and divine favor and engagement. And those presumably would be precisely the same reasons that would be at issue, right, in our debate about torture, whether or not you invoke the further premise of the incarnation, right? So in many of these cases, it seems to me, most religious believers who take whose religion takes that form, really won't be able, of course, you can speak, as you say, in the trappings of religion or with religious language, terminology, cadence, whatever it is, but if we're actually talking about the structure of the arguments and the reasons, I wonder whether there really is the distance between them that you seem to think, unless we get to the case which I agree is the hardest kind of case, and it's the one that I take it that Professor Korsgaard was referencing, which is something like the pure voluntarist God who just says,
Right.
"'Cause,"
Right.
Don't end my life. I don't get to decide to end my life just because God says so, and God doesn't act for reasons. This is just His arbitrary will. Now, if that's your kind of God, then I agree that these will, in practice, there will be this chasm, and I still would agree with you that one should
Right.
not necessarily treat the person who wants to express voluntarism in public as uncivil, but in practice, I think much of the time the gap that you're identifying just won't actually philosophically exist.
Could we collect the other one, and ideally, if it's not a question for Jeremy? Yes.
Hi, Ben Friedman, the Harvard Economics Department. I'd like to suggest a point of tangency between Professor Weithman's and Professor Waldron's comments and see if either or both has a reaction. Leaving Rawls aside, which may be inappropriate at this meeting, my observation about American political discourse today is that the operative question is not whether people who frame their arguments in religious terms have a right to do so, but whether they have a claim on, to use your words, deference or even privilege. And that the question we really face in our society is whether they have some, well, again, your words, whether there is some deference owed to somebody who speaks in the name of the NAE, to take Professor Waldron's example, and if so, how broad is the compass of that deference? Is that all of the 20-odd million members of NAE denominations? Is that everybody in the NCC denominations? Is that non-Protestants altogether? Is there any deference owed? And if so, that creates a certain set of presumptions. But then if not, I think that has interesting implications for the role of many of these groups and their spokesmen for our democratic discourse.
Okay. So I have about 8 people, and we have about 14 minutes, so I'm going to try to move, at least to get them to bear witness, but maybe Jeremy, Euthyphro dilemma in 15 seconds, and Paul, you can answer the...
Right. So to Eric, I mean, many religious arguments have rationalistic structure, and sometimes the content of that rationalistic structure is itself religious, right? So that much natural law theory assumes that there's a God, that He has an interest in mankind, and tries to reason about that. And sometimes the rationalistic structure is kind of secular and would run parallel with religious formulations. And often it's going to be a case of both. Now, I've heard John Finnis giving an argument against same-sex marriage. And all my friends stood up and walked out, and they thought this was highly offensive, not for the reasons that Chris mentioned. He didn't just say Leviticus 3:42. I haven't got the numbers right. He didn't just say that. What he did was elaborate a highly complicated tissue of argumentation with all sorts of frightful logical structure, and only occasional interpolations of sacredness or anything like that. So the mere fact that there's rational structure doesn't necessarily mean that we've solved this problem, because the rational structure may or may not be secular. And my experience has been an awful lot of liberals are troubled by any arguments on these matters. They're troubled by any arguments on these matters, whether those arguments, I mean, the mere fact of being willing to present an argument and present considerations in a logical order has been regarded as offensive. So it's often the argumentativeness itself on matters that people assume must have a religious dimension that commands outrage or offense in these regards.
And a nice example of a position that does have an argumentative structure behind it, I take it, is just the one you mentioned, the power individuals have to end their own lives. One of the things that we owe Jeremy from his Locke book is that Locke thinks we don't have the power to end our own lives. We serve at God's pleasure and not our own, because we're about his business. And that's not, I don't think, an arbitrary claim about our being unable to end our own lives. God has business that he needs us to conduct, and we're not in a position to know when it's done. Now, that's not the kind of answer that will satisfy Chris, quite understandably, but it does reveal the religious argumentative structure behind what can look like a quite arbitrary prohibition on assisted suicide. Now to the question about deference owed to the, I was going to say the NEA, the NAE, the National Association of Evangelicals. And I guess I don't think that religious organizations deserve deference, except perhaps as a pragmatic matter, because they might be quite powerful. I don't think they deserve a kind of rational deference or political deference that other organizations don't get. But I also take it that when organizations like the NAE or the American Catholic bishops write, they're writing for a variety of audiences. They're writing for their own believers, their own flock, but they're also addressing the broader culture. And so I think it's very appropriate that, I think it's perfectly appropriate that they offer arguments couched in their own religious terms. Though I also think that as both pragmatic and principled matter, it's a good idea if they try to offer secular arguments, which aren't translations of the religious ones, but which do try to establish the same conclusions.
I have 10 seconds on that. So if I am correct about the present controversy around Finis, it's not his arguments that are getting him in trouble. It's his other things that he said that express a kind of revulsion, not just about same-sex marriage, but about any sort of sort of sacral intercourse desire for procreation. So that's why he's in trouble. And I'm sort of with Eric on this, make your argument. And it's bad. And nobody's persuaded by it, and he's done it, and now we can move on, right? And so it's the same thing. Once Christians had to argue against same-sex marriage in non-biblical terms, they gave it their best, and they laid it all out there. It ultimately didn't reduce to anything other than animus, and now we're not going to talk about that again, hopefully.
I think that's probably
maybe
true.
I'm not with Eric on this, but anyway, I'm with the idea that if it's a rational view, it can be laid out and then it can be assessed, and that's what it has. But he's not being criticized for arguing.
And so it's a very nice.
He has been criticized for arguing as well.
But this is a very nice example of how the strictures in public reason might have a beneficial effect, because people actually have to express the non-religious arguments for the position.
And there are no good ones, and there we are. Unlike maybe some other things, end of life, beginning of life, there are maybe some very, very complex issues in which it's not just clearly animus, and those endure.
As my friend Andrew Koppelman said, the Emperor Justinian thought that homosexual sex causes earthquakes. If I thought it caused earthquakes, I'd be against it too.
I'll have what he's having.
I know.
Oh, I thought it was a compliment. Okay, sorry.
So I think I'm just going to do a speed collection of the questions and leave things, here we go. So maybe we could go down, Leif and Professor Scanlon and
Leif Winnar. Professor March, thank you so much for this terrific project on Al-Ghanouchi. The ambidexterity with the Islamic and Rawlsian political materials is really fantastic. I wonder if you could say a little bit more on Al-Ghanouchi's category of the unreasonable.
Yeah.
So for Rawls, the unreasonable are essentially people who are not willing to abide by fair terms of cooperation when others are willing to do so. And if you ask Rawls, what is it permissible to do to the unreasonable, he says, in principle, anything that can be contained like a disease. And I'm just imagining that Al-Ghanouchi must have a similar category, because Tunisia's had a bumpy ride and it's in a rough neighborhood. So when West Point did a study about foreign fighters joining al-Qaeda during the American occupation of Iraq, Tunisia sent more per capita than any other country, more than Saudi, more than any. So it's a real Salafist presence, even before the fall of Ben Ali in Tunisia. And there's persistent reports since the democratic transition of the Gulf monarchies who have no reason to want the democratic project to succeed. The Gulf monarchies putting in lots of money to sponsor the recruitment of Salafists and also sponsor attacks so the economy will go bad and there will be more recruitment.
Yeah, yeah.
Okay, so we have significant Salafist presence in Tunisia and this amazing democratic theorist. He must have a category of who is not going to be a voice in this constitutional consensus, and also he must have some sort of principled statement about what can be done to that kind of
Very quickly,
ideology.
the reasonableness. Oh, I'm sorry. You wanted to get more questions?
Professor Scanlon, I think you.
Right, I'll try to be quick. My response, Tim Scanlon, my response is really captures two things that you started off saying, Eric. The first is about the reaction to Rawls, and the second is about what is religion anyway, which you can speak to. I find that pushback somewhat unfair. Rawls's reasons for shifting from the standpoint of the last part of A Theory of Justice to political liberalism was the feeling that in the argument for stability in the last part of A Theory of Justice, he had privileged his own comprehensive view. And he wanted to present an argument for stability that didn't privilege his own comprehensive view. So the idea that this was somehow a move that was bracketing religion, aimed at religion, seems to me quite unfair. Second, the claim that there's some problem in American society that religion's being denied its proper place in the public sphere strikes me as rather strange. I never in my life could have run for national office while declaring honestly my own religious views, which is that I'm a committed atheist. So I don't see, and we aren't hearing a lot of whining about Kantians being denied there. I mean, Rawls is bracketing his Kantianism. We aren't hearing a lot of whining about Kantians being denied their proper place in the public sphere. So that brings me to my second question, which is your hat about, I'm putting on your hat about religious studies. So here we got a panel on religion and liberalism. So what's special about religion that we're talking about it here? If we're just talking about people's beliefs, their comprehensive views or whatever, then they're all on a par. Rawls's Kantianism, as it might be, and all these other views. So why is religion a special category? Is it because there's something about its content that makes it special and gives it some, we ought to give some kind of deference to people's religious views that we shouldn't give to their perhaps quite mistaken views about something else? Or is it a matter that religions are institutionalized? Maybe a religion is a comprehensive view with a bank account and some real estate and a hierarchy, as Paul said, which might be another explanation for what's special. We've got to deal with them because they've got these megaphones. So I don't know. So why are we talking about religion as opposed to general disagreement about the good?
You mean apart from it being the name of the panel?
Professor Rosen, and then
Teresa?
Yeah.
Well, I'm going to recognise that Eric's requirement that we should be pithy, profound, and brief means that I'm disqualified from asking a question. But I will make
British and short.
Yeah, I'm going to make a comment, if I may, just in relation to what Tim Scanlon has just said, which is I think we shouldn't forget that there are two reasons to single out religion. One is the one that he and his fellow non-believers take issue with so famously. Oh, what's so special about religion? Why is it being, as it were, privileged to the point that we talk about it as if it was some special category? There are some answers to that, which even non-believers could accept. But there is another thing, which is, I mean, absolutely central, certainly to the American polity, which is a sense of the special danger of religion. And surely even Professor Scanlon, from his secular point of view, will realize that there are reasons to pay attention to religion, not because of its claims to authority, but because of the certain threats that it provides to the polity. I recognize that in my second concern, religion as a comprehensive view with a bank account and some real estate. They're threats.
So we're supposed to go to 3:15. Maybe I could be a benevolent magistrate and extend that by 5 minutes, cut into your coffee time, because we're still going to have time for that, and then just pick up. I saw one question there in the beard. I'm sorry, I don't know your
Matthew Smith.
Matthew Smith, and then Professor Scheffler and Teresa. That might be all we can do.
Okay. Can we answer some of these? Do you want
Yeah, I do want to answer them, but I'm trying to. Okay.
Matthew Smith, Mr. Philosophy. Jeremy, this is for you, but open things for everyone. You represented political speech and interventions as acts of self-disclosure and maybe self-organization, as if individuals, and I mean that works for religious institutions that have like fully formed doctrinal identities. But I think for a lot of people, political speech, political interventions, political acts are actually part of a process of self-formation, of identity formation, of value formation. So it's not that internally people are like yearning to, they're fully formed politically and they're yearning for a political stage on which to disclose themselves. So perhaps one of the reasons why there should be reservation of a shared space of political speech is to help in the formation of political agents who are committed from the start to a shared political project, right? That forces people in order to articulate themselves in ways that commit themselves from the beginning and not from the edges or from positions apart.
Okay, 2 more, 30 seconds each, and then we'll have 5 minutes to get to the substance of them. Yeah, Professor Scheffler.
Thanks, Matthew.
Okay, this is really a follow-up on Chris Korsgaard's question. First, and it's mostly for Jeremy, 2 points about Rawls's treatment of public reason. The first, Tim has already mentioned, which is that it doesn't just apply to religion. It applies to comprehensive doctrines generally. We've been treating it on this panel as if it was sort of a special thing about religion, but it isn't for him. It's about all comprehensive doctrines. Secondly, the reason for it has to do with his views about what political discourse is. Political discourse involves argument about how to deploy the coercive power of the state. And his view is that in a democratic society, the coercive power of the state has to be exercised by the people, by the citizens. And so when we're engaged in political argument, what we're arguing about, in effect, is how to coerce one another. And that sets up a constraint if it's going to be legitimate. And the constraint is that we have to offer each other arguments that we can recognize as potentially reason-giving for one another. And if I offer you a reason which says, well, I think the state should coerce us and you in the following way, and I'm not prepared to give you a reason that I think you could sincerely recognize as a reason, whether or not you agree with it, then he thinks I've violated the strictures on legitimate political discourse in a democracy. And I guess what I don't, so it's not just about communication in general, it's about a kind of reason-giving communication given the task of political discourse. And my question for Jeremy is, which part of that Rawlsian position do you disagree with? Do you take a different view of what political debate is about? Do you take a different view about what legitimacy is about? Do you think the religious interventions are potentially reason-giving for non-religious people? Or do you think they don't have to be reason-giving?
This builds off that, actually. Firstly, I really appreciate the attention to Jeremy's point about paying attention to forms of speech and engagement that aren't, dialogically and I would just sort of plump for the importance of witnessing as actually a kind of intervening that I think is important. And so I'm going to witness in the style of the Quakers who would interrupt meetings and say, by what authority do you preach? So we can think of that as a speech act. But just Professor Weithman, as I was listening to your talk, the question always in my mind, and it's in my mind when I'm reading A Theory of Justice generally, is doesn't all this concern about deference and institutional privilege and all these, doesn't that just apply so clearly to the university as well as an institution?
Can we just stop there? Because I know we have about 5 minutes. I mean, certainly I would love it if the tax benefits of clergy extended to professors, then that would be a form of deference, but we should get rid of all of that, I think. But yes, so we have about maybe 5 minutes, lots on the table, obviously, specialness of religion, particular questions for particular individuals, but maybe if each of you could, Jeremy, I'll let you go last since there was a kind of onslaught, and then So and maybe we'll just
Deep
go down
and
the line.
pervasive engagement.
Yeah, so very quickly, Leif, I appreciate your question very much. Thank you. If I think I'm paraphrasing Rawls correctly, the importance of reasonableness at this level of forming the social contract is trying to figure out whose agreement matters and who doesn't, right? So if the Nazis or the theocrats say, well, I don't agree to this, doesn't matter, you have unreasonable comprehensive doctrines, that's fine. In the Tunisian context, so the reasonableness is not the foundational concept for Ghannouchi in this way. And as I said in my talk, he isn't actually sitting there rigorously deciding what kinds of disagreements that constrain constitution making should have been reasonable or not. He's taking the existing fact of diversity in Tunisian society as a given, right? As a constraint on constitution making. I focus on the secularists. The Salafis are also obviously part of the story. Electorally, they were very, very small in Tunisia. In Egypt, they were very large, about 25% of the constituent assembly. Had they been larger in Tunisia, and had they had a significant presence in the constituent assembly, then one can only say he would have said, we have to make a constitution with this agreement. And if they were in a position to veto, if they were in a position to obstruct, then we may have had a different sort of constitution. As it happens, they didn't. Now, so as far as the question of Salafi jihadi violence is concerned, he has a very simple answer, which I don't find fully persuasive, but gives some inclination as to a kind of disposition of mind, which is that he says they are a function of the state control of religion under dictatorship. If you had had religious freedom, traditional moderate religion would have been more legitimate, and it wouldn't have been either silenced or completely delegitimized by the state. In that vacuum, then you get Salafis occupying mosques, and they're entering into a religious vacuum. Like I said, I don't particularly think that's all it has to say. And then a final point on that, there's a difference between who is entitled to act as a kind of veto point on a social contract because they're reasonable, and those who are still entitled to civil and political liberties. So he treats the Salafis as just another, and not all Salafis are Salafi jihadis, by the way. So he treats them as just another religious group who should have their mosques, have their religious, and that they should be debated and argued with, and they should not cease to be objects of civil and political toleration.
Okay, Paul and then Jeremy.
I'll start with Teresa's question and then turn to Tim's. Just on Teresa's question, undoubtedly there are great asymmetries of power within universities, and those asymmetries lend themselves to abuse. I think it's an interesting question whether the asymmetries are the same as within ecclesial structures. Certainly there are different accounts of the sources of the authority in question, the power in question within them. So I would just wonder if that's an interesting difference, or maybe it's a distinction without a difference. I'm not sure. I'm also not sure whether there is within the larger culture the kind of deference to universities that there has been to some churches. If in fact there is, then I'd say it should stop too. That's a consequence that I'm happy enough to accept. Though I don't see any great deference to universities and the expertise of which they're in possession. We're not at that political moment right now. Now turning to Tim's question, I think that there is considerable historical interest, at least, and momentum behind the question of the relationship of religion and liberalism, because not only, I suppose, did liberalism emerge out of the wars of religion, to follow Rawls's narrative, but also it emerged from an attempt to free people the powers of the church. So historically, I think religion has been seen to be antagonistic to religion, and religious conceptions of the good are those conceptions of the good to which people have long thought liberalism is most opposed. And so I think it's a really interesting question whether that is still so. And my own view is that Rawls, particularly in his later work, is not vulnerable to that charge. But I do think it's a really interesting question to consider. Had Michael decided to include Kantians and whether Kantians have a right to complain, I wouldn't object, but I probably wouldn't be here either. So I'm grateful he made the decision that he did.
Jeremy, quickly, if you could.
Okay, thank you very much. Why aren't we just talking about comprehensive views generally, since that's the way the Rawlsian position is framed? The panel was on religion, Tim. I didn't choose the title. Religion is certainly comprehended in the category comprehensive views. If you want my views on the exclusion of Kant and Raz, then you can predict what they are. If you want my views on perfectionism, then they're much more closely aligned to Rawls's. But we bring religion into the picture partly in relation to some of the issues that cropped up this morning's panel. Because whether you guys like it or not, some of the most powerful sentiments about the importance of justice and some of the most powerful sentiments about the characterization of the most vulnerable members of the society do tend to be put forward by religious people. And if a new category of vulnerability were to emerge, whether it's old people at the end of life, and there was some question about end-of-life arrangements, and somebody said, well, Waldron, would you go off and find what reasons there are for and against this matter? I would certainly want to listen to I don't know, what the Conference of Bishops was saying or what various religious leaders were saying, just as a matter of thinking that they're likely to have thought hard about this issue. Now, it is true that sometimes the reasons that religious leaders will put up are not immediately accessible to those to whom they are addressed, if they're addressed to their fellow citizens. But I went out of my way in the talk to talk about multiple modes of access to religious ideas. That they can be accessed imperfectly, partially, and I believe all communication and normative argument is imperfect and partial. And sometimes you have to go away and read a book. So access is not always simplistic. And it would be a sad day for political deliberation if we were to insist that anything that cannot instantly be understood has to be excluded. So I accept the reason-given characterization, although I enjoyed the testimony from Sister Bijan about the diversity of speech acts in politics as well as in Quaker meeting houses. I think it's important. Matthew talked about a shared political project. I'm sorry.
I'm being overruled by the chair of chairs.
Okay.
So if we, I think maybe I will just take. In my report at the beginning was not an endorsement of this reaction to Rawls. It was just an anthropological note from the field. And maybe in our next session, I think there's more attention to the difference principle now among religious constituents than the idea of public reason. But thank you for indulging us going over time. Please don't let that prevent you from showing up exactly at 3:45 for the start of the next panel, which will end promptly at 5:45 for the 6 p.m. keynote. Enjoy the 25 minutes you have of coffee. So thanks to our presenters.